This video is for you if you are ready to start, respond to, or finish a family law case, or if you simply want to gather information and are not yet ready to file any documents. We will provide an overview of the process from start to finish for divorce cases, child custody and support cases, and paternity cases. The Family Law Facilitator and Self-Help Center staff are available to answer general family law questions from parties who do not have an attorney. The Family Law Facilitator is not your lawyer, but is a neutral person who does not represent either parent or party in the case. There is no attorney-client relationship between you and the Family Law Facilitator. We may provide assistance to both parties in the same case. Communications between you and the Family Law Facilitator's office are not confidential. We can give you general and neutral information, explain your options, give you definitions of legal words, and give you instructions regarding the legal process. We cannot give you our opinion, tell you which option to choose, or tell you what we think is in your best interest. In this video, we will go over the steps to start and finish a family law case. We will go over each step individually in more detail. Step 1 is to complete several forms to start the case. One of the most important forms in this step is the petition. The form will tell the court and the other party what is being requested, including child custody, visitation, and child support. The person who completes the petition will be referred to as the petitioner for the duration of this case. A petition for divorce or legal separation will also state the orders that the petitioner wants regarding spousal support, division of assets and debts, and restoration of the petitioner's former name. It is very important to note that if the petitioner does not ask for something in the petition, the judge may not be able to make orders about it at the end of the case. Along with the petition, the petitioner will need to provide the court and the other party with information about their income and expenses. If the petition is for divorce or legal separation, then the petitioner will also need to provide the court and the other party with information about all of the assets and debts that exist. This is a process called financial disclosure. We will go over this in more detail later on in the video. Step 2 is to file the completed forms with the court. Documents may be filed in person at the San Luis Obispo or Paso Robles courthouse. Counter hours vary by location. Please check the hours on the court website before visiting the courthouse in person. Documents may also be filed by mailing them to the court or by placing them in the drop box that's located outside of the San Luis Obispo or Paso Robles courthouse. If the documents are filed in person, by mail, or through the drop box, then the originals plus 2 copies of all the forms must be included, along with a self-addressed stamped envelope, so that the court can mail the copies back to the petitioner once they are processed. Documents can also be filed electronically, which is referred to as e-filing. In order to file electronically, an online account needs to be created through the San Luis Obispo Superior Court's website. Once the account is created, PDF copies of the documents may be uploaded and submitted for filing. If the petitioner files electronically, the court will automatically email the petitioner a copy of the filed forms. In addition to assigning a court case number, the court clerk will also produce a notice of case assignment. This document will let the parties know the name of the judge assigned to the case. If a divorce or paternity case was filed, this form will also let you know the first date that the judge will review the status of your case. This is called a case status conference. It is very important to understand that this status conference date is not the date the judge will grant a divorce or make any orders. It is simply to let you know that your case is not yet finished and there are more documents you need to complete. The court is required to review your case every 6 months for the next year and a half to inform the parties that the case is not complete. If your case is not finished within 5 years, the court may close your case. The court has taken on this proactive role to prevent people from filing a case and then coming back 10 or 20 years later and discovering that the divorce process was never completed and they are still married. Do not come to court on the day of your status conference. This is a case review performed by the judge, and that a status conference order will be mailed to you with details of the additional forms that need to be filed to finish your case. After the documents have been filed with the court, step 3 is for the petitioner to have a copy of the filed documents delivered to the other party's attorney or to the other party if they are not represented by an attorney. The petitioner is responsible for selecting someone else who is 18 years of age or older to personally deliver the documents to the other party. This is called personal service. The petitioner cannot be the one to deliver the documents. The person who delivers the copies can be a friend or relative, the sheriff's department, or a private process server. The sheriff's department or a private process server will charge a fee to deliver the documents. The sheriff's department will waive the fee if a fee waiver was granted by the court. If the other party is represented by an attorney, then the documents must be delivered to the attorney. The person who delivers the forms will likely not give them directly to the attorney, but to a receptionist or someone else who works in the attorney's office. The person who personally delivers the documents must complete, date, and sign the FL 115 Proof of Service of Summons form. They will need to write down the date and time and the address of the location where the documents were delivered to the other party. The petitioner should then make a copy of the completed FL 115 Proof of Service of Summons form for their own records and file the original with the court to show proof that the other party received the proper documents. Step 4 is to wait 30 days from the date the documents were delivered to the other party. The person who received a copy of the filed documents is also referred to as the respondent. The respondent has a minimum of 30 days from the date that they received the forms to respond to the case by filing a response document. If the response document is not filed, the petitioner can file additional forms to move the case forward without the respondent's participation. If the respondent does not file a response within 30 days, they may still be able to file a response if the petitioner has not yet completed additional forms to move the case forward. Step 5 is to complete an online parenting class. If you have minor children, you can complete the parenting class. This course covers some common challenges that parents may face while living separately and raising children, and possible solutions. A link to the free online parenting class can be found on the court's website. Once you finish the course, you can print the certificate of completion and file it with the court. Step 6 is for the petitioner to complete financial disclosure and decide how to finish the case. There are 3 options to finish the case. Option A is by default. Option B is uncontested or by agreement. Option C is by trial. Option A is to finish the case by default. This is an option only if the respondent did not file a response document and at least 30 days have passed from the date the documents were given to the respondent. To finish the case by default, the petitioner will need to file additional documents with the court. The final orders must match exactly the orders that were originally requested in the petition that was filed at the beginning of the case. Additionally, in a divorce case, the court must equally divide the assets and debts that were acquired during the marriage. If the petitioner is receiving more of the assets than the respondent, the petitioner will have to pay what is called an equalization payment. For example, if the assets the petitioner will receive have a value of $1,000 more than the value of the assets the respondent will receive, the petitioner will have to pay the respondent $500 to equalize the value of the assets that both parties are receiving. Once the judgment documents are filed, the judge will review the paperwork. If everything looks correct, the judge will sign the final judgment document, and the court will mail a copy to both parties. This will all happen without a court hearing in front of the judge. If the case is finished by filing a default judgment, the respondent has up to 6 months to request that the court cancel the orders in the default judgment so the respondent can file a response and participate in the case before the final orders are made. Please note that default is not an option if the respondent is an active member of the military. Option B is to finish the case by agreement if both parties are in agreement on all the issues, including child custody and visitation, child and spousal support, and division of assets and debts. This option is available whether or not the respondent filed a response. If the case is finished by agreement, the parties are not limited to what was requested in the petition or the response. The terms of the agreement can be whatever the parties decide on. Before moving forward with an agreement, both parties must complete the financial disclosure process. The parties will then need to prepare their agreement forms and sign them in front of a notary. Once the agreement documents are filed, the judge will review the paperwork. If everything looks correct, the judge will sign the final judgment document and the court will mail a copy back to both parties. This will all happen without a court hearing in front of a judge. Option C is to finish the case by trial. This is an option if the respondent filed a response and the parties are not in agreement on all the issues. One of the parties will need to request a hearing, also called a trial, so that the judge can make orders regarding the issues that the parties disagree on. Before a trial can be requested, both parties must complete the financial disclosure process. Regardless of which option is chosen to finish the case, there are additional documents that need to be completed and filed with the court. No orders will be made unless these documents are filed, and the case will remain incomplete. Step 7 is to complete the judgment paperwork and file it with the court. The judgment documents are the last forms that are needed to complete the case. The judgment will outline the court orders on all issues. Remember that in a divorce case, the parties are not divorced until they receive a copy of the signed judgment back from the court, and at least 6 months and 1 day have passed from the date that the respondent was served with the original petition. If you are starting or responding to a case, there are some general things you should know. The summons, which is one of the first documents that must be filed with the petition, contains some standard restraining orders that go into effect against the person who starts the case as soon as the documents are filed. These standard restraining orders go into effect against the other party when they receive a copy of the filed documents. One of the standard restraining orders prevents either parent from removing the minor children from the state of California without a court order or written permission from the other party. In divorce cases, the standard orders also prohibit both parties from making changes to insurance plans. For example, one person cannot take the other person off a health insurance policy. The standard orders also limit the buying and selling of assets. Of course, people are allowed to pay their bills and carry out other necessities, but the court generally wants the parties to keep things the same. There are specific residency requirements that need to be met if the petitioner is filing a divorce case. To file for divorce in San Luis Obispo County, at least one of the parties must have lived in California for at least 6 months, and in San Luis Obispo County for at least 3 months prior to filing. If neither party meets this requirement, they will need to wait to file in San Luis Obispo County until they do, or they can choose to file in a county where one of them does meet the residency requirement. There are also residency requirements that must be met before court orders can be made regarding child custody and visitation. The children must have lived in California for at least 6 months prior to filing the case, and there must not be any other case involving the children in another county or state. If you are filing or responding to a case that involves minor children, you will need to fill out Form FL-105, Uniform Child Custody Jurisdiction and Enforcement Act. This form is used by the court to determine whether the judge has the power to make orders regarding the children. The form asks for information about where the children have lived in the past 5 years and whom they have lived with, as well as any other court cases that may involve the children. You must also inform the court if there are any active restraining orders and whether anyone other than the parents is requesting custody of the children. The person who files the first documents to start the case will always be called the petitioner, and the other person will always be called the respondent. These titles will not change for the lifetime of the case. If you file documents into the same case in the future, you will have the same title as when the case was first filed. It is important to keep your contact information updated with the court. If the mailing address listed on your court documents changes, you must complete Form MC040, Notice of Change of Address, to notify the court of the new address where documents can be mailed to you. The original must be filed with the court and a copy must be mailed to the other party. If you start using a new address on your court documents without updating it using this form, you may not receive notices from the court and legal documents from the other party in a timely manner. There is a filing fee of $435 for the petitioner to start the case. This fee will be charged when the petition documents are filed with the court. There is also a $435 filing fee for the respondent to file a response or other document in the case. If you cannot afford the filing fee, you may request a fee waiver from the court. You will need to fill out Form FW001, Request to Waive Court Fees, and Form FW003, Court Order on Fee Waiver. You may apply for the fee waiver under one of three options. You can select option A if you are receiving assistance through a government program such as food stamps, SSI, Medi-Cal, CalWORKS, WIC, or unemployment. You can apply under option B if your gross monthly household income is below the guideline amount listed on Form FW001, Request to Waive Court Fees. If you do not qualify under option A or B, you can select option C, which states that you do not have enough income to pay for your basic household needs and the court fees. In this option, you can request that the court waive some or all of the filing fees or implement a payment plan for you. If you apply under this option, the judge that is assigned to your case will review your fee waiver request and determine whether the request should be granted or denied. If the fee waiver is denied, you have the right to request a hearing within 10 days to give the judge additional information about why the fee waiver request should be granted. Now we'll talk about completing the necessary forms for a case. The forms can be found in a few places. They are available for free online at courts.ca.gov. Once you navigate to the website, you can search for the forms by form number or form name. You can also purchase a packet of blank forms for $5 at the court clerk's office in the San Luis Obispo or Paso Robles courthouse. The forms can also be completed using a free online form preparation program that can be found on the court's website. The program will ask you questions, and the answers that you provide will be used to complete the forms for you. This program can be used to create the original petition or to respond to the petition documents. After you complete the forms, we highly recommend that you schedule a document review appointment with the Self-Help Center so we can review your drafts before you file them with the court. You may type or handwrite your forms. If you choose to fill them out by hand, you must use blue or black ink only. If you make a mistake on your forms, you can use whiteout to correct it. Most of the forms that you complete will have this caption at the top. It is important to fill it out completely and correctly on each form that you file with the court. The first box is for your name and contact information. Remember that these are legal forms, so you should use full legal names and keep the names consistent on all of the forms that you complete. The mailing address does not need to be your home address. It just needs to be a safe address where you can receive mail. Remember that the other party will receive a copy of all of your forms and will see the contact information that you provide. If you do not want the other party to know where you live, you can use a mailing address on your court forms instead. The phone number and email address are optional. The second box is for the court address. The court location for your case is determined based on where the petitioner lives. If you are filing the petition documents, you will use local form FL013 Statement of Venue to determine the correct court address to use. We will review that form in a moment. In the third box, you will list the petitioner and respondent, again using the full legal name for each person. The designation of petitioner and respondent do not change for the lifetime of the same case. The person who filed the documents to begin the case will always be the petitioner, and the other person will always be the respondent. It is also important to include the correct case number on your forms. When the petitioner fills out the petition documents, there will not be a case number yet, so this section can be left blank. Once the petition documents are filed, a case number will be assigned. Both the petitioner and the respondent must use this case number on any subsequent documents filed into the case. The petitioner will also need to complete local form FL013 Statement of Venue to determine which court location the case will be assigned to based on the petitioner's home address. Generally, if the petitioner lives south of the grade, the case will be assigned to the San Luis Obispo courthouse. If the petitioner lives north of the grade, the case will be assigned to the Paso Robles branch. If the case involves minor children, both the petitioner and the respondent can ask the court to make specific orders regarding the children. In the next part of this video, we will go over the definitions of custody, visitation, and child support. First, we will talk about custody and visitation. There are two types of custody: physical custody and legal custody. Physical custody refers to who the child primarily lives with. Legal custody refers to the parent's right to make decisions relating to the child's health, education, and welfare. There are two types of physical custody: joint physical custody and sole physical custody. Joint physical custody is when both parents spend a substantial amount of time with the child. This does not necessarily mean that both parents have equal time with the child. There is no set definition of what a substantial amount of time is. If joint physical custody is requested, then the parent can request a specific schedule that details the days and times the child will be with mom and the days and times that the child will be with dad. Sole physical custody is when the child primarily lives with one parent. The time spent with the other parent is usually called visitation. Visitation is the term we use to define the time that the child spends with the parent who does not have primary physical custody. Visitation is a form of physical custody because it defines the days and times that the child will physically be with the other parent. Some options include reasonable visitation, a specific schedule, or supervised visitation. You can use Form FL 311 Child Custody and Visitation Application Attachment to indicate the orders that you want the court to make regarding physical custody, legal custody, and visitation. It can also help you create a schedule of the specific days and times that each parent will spend with the child. There are several visitation options on this form. The first option is reasonable visitation, which means that there will not be a specific schedule in the court order. The parents will need to work out a schedule together to decide when the child will be with each parent. Because the schedule is not a court order, it may be difficult to enforce. If one parent refuses to return the child to the other parent, law enforcement will generally not be able to intervene and will instruct the parents to return to court to obtain a more specific order. Another option for visitation is a specific schedule. The court order will specifically state the days and times the child will be with mom and the days and times the child will be with dad. If a specific schedule is ordered by the court, it must be followed until it is modified by a judge or the parents agree on a different schedule. You can also request supervised visitation, but you will need to prove to the court that there is a valid reason that the child cannot be safely left alone with the other parent. Supervised visitation may be supervised by a professional supervisor or a non-professional supervisor such as a friend or relative. The other kind of custody is legal custody. This establishes which parent is going to make decisions relating to the child's health, education, and welfare. There are also two types of legal custody: joint legal custody and sole legal custody. Joint legal custody means that both parents make decisions relating to the child's health, education, and welfare. Sole legal custody means that only one parent is making these decisions. If you request joint legal custody, there are essentially two options. The first type of joint legal custody is when both parents must discuss the issue and come to an agreement on every decision that is made for the child. The second type of joint legal custody is when each parent can act alone to make a decision, as long as it does not interfere with the other parent's right to physical custody or visitation time. For example, mom could choose to enroll the child in soccer without discussing it with dad, as long as the soccer practices and games do not interfere with dad's days and times with the child. You can also choose to request a combination of joint legal custody in which both parents must agree on certain decisions, while they can make others alone without input from the other party. If you want to request joint legal custody where both parents must agree on all decisions that are made for the child, you can use Form FL 341E, Joint Legal Custody Attachment. In Item 2, you can indicate the types of issues for which both parents must come to an agreement before a decision is made. Now we will talk about child support. At the time that the judgment is signed for a family law case, the judge will make orders regarding child support if there are minor children involved. If you want to obtain child support orders before the end of your case, you can file a request for order on your own for this issue, or you can contact the Department of Child Support Services for assistance. The Department of Child Support Services, or DCSS, is a county agency that helps prioritize child support cases in the court system. The Department of Child Support Services can help both parents regarding child support issues. DCSS offers a variety of free and neutral services to both parents, including establishing, modifying, and enforcing court orders for child support or health insurance. They can also help locate a parent and establish paternity. DCSS also keeps records of child support payments made and arrears or unpaid child support that has accumulated over time. The Department of Child Support Services has many enforcement abilities to encourage payment of child support orders. The department can suspend a variety of licenses due to unpaid child support. They can also place restrictions on passports, port non-payment to credit agencies, place liens against assets, and intercept tax refunds and lottery winnings. DCSS can also take further legal action, including filing for contempt, which may carry criminal penalties. DCSS also has a variety of payment options available. You can apply for services by going in person to the local child support agency located at 1200 Monterey Street in San Luis Obispo. You can also apply online using the application at childsupport.ca.gov or by calling 866-901-3212. Child support is calculated using a mathematical equation that balances multiple different factors. The court will examine three main factors to determine guideline child support: mom's income, dad's income, and how much time the child spends with each parent. This means that even if the parents share custody equally, one parent may still be ordered to pay child support if they make more money than the other parent. If you apply for assistance through the Department of Child Support Services, they will run the guideline calculation for you. If you choose to establish or modify child support on your own through a request for order, you can also run the guideline calculation yourself using the child support website. In this next section, we will discuss some of the legal issues that might come up during a divorce. The date of separation is the date that, in your mind, you knew the marriage was over and did something to show that you no longer wanted to be married. This does not have to be a grand gesture such as moving out. This date is important because it impacts spousal support orders and the division of assets and debts. Spousal support is financial support that the court can order to help keep the standard of living the same for the receiving party at the time the divorce is granted. On the petition and response forms, there is a section regarding spousal support. There are three options in this section, and you must tell the court which option you want for yourself and the other party. Option A is to request that the judge order a specific amount of spousal support. This means at the end of the case, one party will be ordered to pay a specific amount to the other party. Option B is to request that the court terminate or close the door forever on the ability of the party or parties marked to ever receive spousal support. In a long-term marriage, which is defined as a marriage of 10 years or more, the state legislature has asked the courts not to terminate the right for either party to receive spousal support. Instead, the courts will reserve that right, which means the court can make orders about spousal support in the future. Option C is to reserve the right to receive spousal support for the party or parties marked. The judge will take several factors into account to decide whether to award spousal support, how much to award, and for how long. Some of those factors include the other spouse's ability to pay spousal support, the requesting spouse's need to receive spousal support, the standard of living during the marriage, and whether there was domestic violence in the marriage. Financial disclosure involves both parties filling out a set of documents to declare all income, expenses, assets, and debts that both know to exist. This is an important step that must be completed in full. If you leave anything out, by mistake or on purpose, your proposed division of property may not be accepted by the court and your case could be reopened or changed. Financial disclosure is required at the beginning of your case, which is called preliminary disclosure, and at the end of your case, which is called final disclosure. Financial disclosure requires you to list all property and debts that you know to exist for either party. This is done by listing all property on Form FL-160 Property Declaration based on the date that the property was acquired. There are two types of property: community property and separate property. Community property is defined as any asset or debt that was acquired after the date of marriage and before the date of separation. There may be some exceptions to this rule. One exception is that any inheritance or gifts acquired during the marriage may be considered the separate property of the person who received them. California is a community property state. This means that the assets and debts acquired during the marriage are owned equally by both spouses, regardless of whose name is on the property or whose money was used to purchase it. If you are moving forward by default or trial, The court will divide the community property equally between the parties. If you are moving forward by agreement, you and the other party can agree to divide the community property unequally. Separate property is defined as any asset or debt that was acquired before the date of marriage or after the date of separation. This is an example of Form FL-160 Property Declaration. Generally, you will need to complete 2 of these forms, one for separate property and one for community property. It is important to fill out each column completely and correctly. Columns C through F must contain a dollar amount. Column A is a description of the property. Be specific in this field so that the judge can easily determine what the item is. For example, you could include the last 4 digits of a bank account or the make, model, and year of a vehicle. Column B is the date you acquired the item. For some items, such as checking accounts or credit cards, this will be the date that you earned the money in the account or acquired the debt on the card, not when you opened the accounts. This can be a specific date or a range of dates. Column C is the item's gross fair market value. This is what you could sell the item for today, not what you originally paid for the item. If you're unsure of the amount, you can use your best judgment to estimate the value. Column D is any debt that is owed on the item. Column E is the item's net fair market value. This is calculated by subtracting column D from column C. In this example, column C shows the gross fair market value of the real estate property is $300,000, and column D shows the amount of debt on the property is $100,000. The amount of debt in column D is subtracted from the gross value of the property in column C to get the net fair market value of $200,000, which goes in column E. Column F is your proposal for division. You use this column to show who will receive the asset or debt. Sometimes the total in column E can be divided in this section under both parties to show that each of them are receiving a portion of the asset or debt. Make sure that you also total up each column at the bottom of pages 2 and 3. Sometimes the value of an item of property, such as a retirement account, is earned over a period of time that includes before marriage, during marriage, and after the date of separation. In this example, there is a 401k account that has a total value of $5,000. The money in the account was earned before marriage, during marriage, and after the date of separation, so the 401k needs to be listed on both the separate property declaration and the community property declaration. The account will be listed on the FL-160 for community property with a value of $3,000 and a date range from the date of marriage to the date of separation. The same account will also be listed on the FL-160 for separate property with a value of $2,000 and a date range from the date the job was started to the date of marriage, and another date range from the date of separation to the date that the 401k stopped gaining money. Pensions and retirement plans can be the most valuable asset acquired during the marriage. There are very specific and technical rules that apply to pension plans. You may want to seek legal advice from a lawyer to protect your interest in the pension. In some cases, a pension plan must be joined or added to the case before the judge can issue an order about how the pension will be divided. You can read Form FL-318, Info Retirement Plan Joinder Information Sheet, for more information. The court order that details how a pension plan will be divided is called a Qualified Domestic Relations Order, or a QDRO for short. This order must be approved by both the pension plan provider and the judge to ensure that it is correct. This is a complicated legal document, and if you make a mistake, there can be harmful results. You can reach out to your pension plan administrator to ask them if the plan must be joined to your case and if they can send you a sample QDRO to review. As part of the process of financial disclosure, you will also need to complete Form FL-150 Income and Expense Declaration. This is a 4-page document in which you will detail your gross monthly income and expenses. One of the most important questions on this form is item 4 on the first page. This section asks you to estimate the gross monthly income of the other party and explain what your estimate is based on. The judge will use this amount for the other party when calculating child support or spousal support. This amount can be your best guess and does not need to be exact. If the other party disagrees with your estimate, they have the chance to respond with their own form. Let's take a closer look at some of the areas of this form. In item 5, you need to detail your last month's income and your average monthly income from all sources, using the amount before taxes. To calculate your average monthly income, Add up all of your income from the last 12 months and divide it by 12. Item 12 asks you to list everyone who lives in your household, their age and income, and if they contribute to the household expenses. This includes minor children who live with you. In item 13, you'll need to list your estimated monthly expenses for each category that applies to you. For item 14, you will need to list any items for which you're making monthly payments, such as a credit card or a car loan. Then add up all of the monthly payments and write that total on line P in item 13 above. Now total up all of your monthly expenses and write that total on line R, total expenses. There's also a place to indicate whether anyone else is helping you pay your expenses. When you file this form with the court and serve it on the other party, you will also need to attach your last 2 months of pay stubs. Rule 2.8 of the San Luis Obispo County Family Law Policies and Procedures Manual also requires that you exchange additional financial documents with the other party and file a declaration with the court that lists the documents that were exchanged. You will need to provide the other party with a copy of the following documents: your last 6 months of pay stubs, last 2 years of tax returns, last 12 months of bank account statements, last 2 years of 1099s, W-2s, and K-1s, and other documents as required by the policy. If you want to save time or don't want to fill out all your forms by hand, you can use our free online form preparation program to prepare your documents. This form is available for both the petitioner and the respondent. The program will ask you questions, and your answers will be used to complete the forms. The program helps to explain sections of the forms that may be confusing and prints your documents in a neat, legible type that is easy for anyone to read. If you choose to use the form preparation program, just be aware that it can only complete the forms with the information that you provide. If you provide incorrect or incomplete information, the program may not be able to correct it, and your forms could be rejected by the court when you try to file them. We highly recommend that if you use the form preparation program, you email a draft of your documents to the Self-Help Center and schedule a document review appointment before you file the forms with the court. If you would like to use the online form preparation program, you can visit the San Luis Obispo Superior Court website at slo.courts.ca.gov. Click on the Online Services drop-down menu, then select Online Form Preparation. This will take you to a page with links to all of the available form preparation programs. Scroll down to find the case type you are looking for and click on the link. You must create an account so that you can save your work and download and print your forms. Once you have opened your account, you can proceed with the interview. Click Start on the first section to begin. You will need to open each section in order to complete the interview. If a particular section does not apply to you, the program will skip you to the end of that section. When you have completed the entire interview, you will be able to download and print your forms. You can find more helpful information on the San Luis Obispo Court website. If you have further questions, you can attend our weekly Family Law Case Information webinar through Zoom at 2 p.m. on Wednesdays. We host a live Q&A session at the end of the webinar around 3 p.m. where we can provide general and neutral information in response to your questions. Give the Self-Help Center a call at 805-706-3617 to schedule an appointment. You can email your documents to us at finishcase@slo.courts.ca.gov.